Yesterday, a federal court of appeals determined that suppressors are not arms and therefore are not protected by the Second Amendment. It's definitely an interesting decision, but what is more interesting is the court which came to this conclusion. So let's talk about this interesting and surprising ruling today. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a practicing Second Amendment attorney and host of the Firearm Firm channel. Today we're talking about suppressors, and as you probably already know, suppressors fall under the National Firearm Act, and in order to legally possess one, you have to jump through some additional hoops, including having to pay for a government-issued tax stamp, which most, if not all, in the 2A community, including myself, think is absolutely ridiculous. So yesterday, February the 6th, 2025, a three-judge panel from the United States Court of Appeals for the Fifth Circuit issued an opinion in United States versus George Peterson, finding that suppressors do not fall under the protection of the Second Amendment. Now, this determination was definitely surprising, but what really took me off guard was that the Fifth Circuit came to this conclusion. I mean, since the 2022 decision in New York State Rifle and Pistol Association versus Bruin, the United States Court of Appeals for the Fifth Circuit has been killing it by striking down government infringements on the Second Amendment left and right. So I'm really not understanding what happened in this case, but here we are. So here is a quick breakdown of the facts in the case. In the summer of 2022, ATF obtained a search warrant for Peterson's home, which resulted in finding a homemade suppressor in a safe located in Peterson's closet. The suppressor, it did not have a serial number on it, and it was not registered in the National Firearms Registration and Transfer Record. ATF had obtained the search warrant based on Peterson selling two handguns to an undercover officer and not reporting the sale in violation of 27 CFR 47D8.126A. Another time, an undercover agent conducted a strawman purchase with Peterson for two firearms, and also ATF believed that Peterson had lied on his federal firearms license application by indicating he would only conduct business at gun shows and out of a leased storage unit, when in fact he was actually conducting business out of his home. After Peterson was indicted by a grand jury for possession of an unregistered suppressor, he filed a motion to dismiss based on the NFA's registration scheme, violating his Second Amendment rights. He also filed a motion to suppress the evidence that was found as a result of the search warrant because the search violated his Fourth Amendment rights. The court denied both motions, and he ultimately entered a plea reserving his right to appeal. As mentioned earlier, the Fifth Circuit ultimately determined that suppressors are not arms within the Second Amendment purview. So let's see how the three-judge panel came to this not so brilliant conclusion. First, the court, citing to the Heller case, looked at what all the Second Amendment covers, and they wrote, "The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And as both parties agree, arms in the Second Amendment sense comprises weapons of offense, armor of defense, and anything that a man wears for his defense, takes into his hands, or useth in wrath to cast or strike another. That is, to constitute an arm, the object in question must be a weapon." Peterson argued that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. The court wrote, "Inasmuch as a bullet must pass through an attached suppressor to arrive at its intended target, suppressors are used for casting and striking and thus fit Heller's definition." But that's wrong. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense, and unless the suppressor itself is thrown, which of course is not how firearms work, it cannot do any casting or striking. While a suppressor might prove useful to one casting or striking at another, that usefulness does not transform a gas dissipator into a bullet caster. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of firearm accessories is not. Peterson then argued that arms include the proper accoutrements that render the firearm useful and functional. But the court agreed with the government's argument that an operable firearm will work perfectly well without a suppressor, but a suppressor will not transform an inoperable firearm into an operable one. Lastly, Peterson argued that the right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use. But once again, the court disagreed with him, noting that the use of a suppressor, as we noted above, is not necessary to the use of a firearm, so it is not protected by the plain text of the Second Amendment. The court concluded their opinion regarding Peterson's Second Amendment violation claim, writing, "The Second Amendment therefore is not offended by the NFA regulation, so we affirm the district court's denial of Peterson's motion to dismiss." I don't know about you, but the NFA regulation, it definitely offends me, and I'm pretty sure it would offend those who wrote the Second Amendment. This ruling has the potential of causing all sorts of dangerous issues down the road if it remains standing. First, if the court takes the position that all suppressors really are attachments, this opens the door for other attachments to be banned by the states. Second, if suppressors do not fall under Second Amendment protection, then what would keep states from plain out banning them for whatever trumped up reason they decide to? I assume Peterson is going to ask for an en banc hearing in which all the judges for the Fifth Circuit would get a chance to weigh in and hopefully set aside this ruling. I assume, like me, you totally disagree with this opinion, but be sure to let me know what you think down below in the comments section, where you can also leave any questions you may have about this video or any other Second Amendment related question. Until next time, stay armed and educated.